Thank you. Very good afternoon, everybody. I'm CSR Venkatramana, Council Member, moderator for the session. Friends, we are joined for most complicated and typical topic of prohibition of insider trading regulations and database. Triple E. I welcome you all to this Triple E 5.0 Master Knowledge Series program. To focus on practical aspects of prohibition of insider trading and structured database. Friends, we have with here today Shri Mr. Sanjay Parov sir, CGM of SEBI, and Savitri Parekh, and also we have Mr. Manish Dio and Mr. Vishnu Gupta, who are from NSE to give their guidance and clarifications on various matters relating to this typical topic. Friends, as you all know that prohibition of insider trading refers to a regulatory framework that prevents individuals and entities with access to unpublished price sensitive information from trading of securities in an unfair advantage over the general public. Friends, SEBI Insider Trading Regulations 2015 has given a comprehensive regulations to govern this area and also aiming to ensure fairness, transparency, and integrity in the securities market. The regulations define the insider as any person who is connected to a company or who is having access to UPSI, including directors, employees, auditors, consultants, even legal advisors, apart from immediate relatives and connected persons. Friends, we all know that even as a practicing company secretary, secretarial auditors, who may also be treated as connected persons. The law prohibits such insiders from buying, selling, dealing with the securities when in possession of UPSI and mandates strict compliance of measures such as trading windows, pre-clearances of trades, and disclosures by promoters and key managerial personnel. As a compliance officer, the company secretaries had utmost responsibility in compliance with these regulations and to ensure that there is no insider trading happening and there is a internal controls, specific controls to ensure that the insider trading is prevented. Friends, the violations of these regulations can also lead to severe penalties, including monetary fines, market bans, and imprisonments, reinforcing SEBI's commitment to maintain a fair and efficient capital market. Friends, the SEBI Prohibition of Insider Trading regulations came in 2015 and they have been amended from time to time to see in 2018 and 2019-20 there are major amendments to these regulations, and in the year 2018 the structured digital database has been introduced by SEBI, which plays a critical role in ensuring transparency and preventing insider trading. The concept of SDD is a particularly emphasized to mandate the maintenance database by listed entities and by certain intermediaries. Friends, we have also seen that SEBI has been issuing settlement orders in cases of involving insider trading. Recent case is Balaji Mines Limited, and final orders are issued in major giants also like Infosys Limited and Hindustan Aeronautics Limited. SEBI has been providing informal guidance as well in the matters of insider trading, prohibition of insider trading, regulations, clarifications. Now, if you see the sectoral database where company secretaries in practice are required to issue certificates, which is a secure and computerized registry maintained by listed entities, fiduciaries, and intermediaries to record the flow of unpublished sensitive information. The core objective is to track the sharing and usage of UPSI to ensure the compliances of insider trading regulations and to promote accountability and to safeguard and misuse of price sensitive information. Friends, the introduction of SDD requirement has significantly strengthened the corporate governance framework, and it has compelled companies intermediaries to implement robust internal controls and systems to monitor the flow of sensitive information. Friends, SDD particularly applies to the listed companies and market intermediaries like merchant bankers, law firms, auditors, consultants, including secretarial auditors who handled UPSA and fiduciary as defined under SEBI norms. Fiduciaries is referred to as in explanation regulation 9(2) the regulations, which leads to professional firms such as auditors, accountancy firms, law firms, analysts, insolvency professional entities, consultants, and banks. Assisting or advising listed companies shall be collectively referred as fiduciaries. Accordingly, the company secretary is in practice dealing with UPSI of listed entities and unlisted entities whose securities are proposed to be listed. Any failure to maintain such structural digital database or improper maintenance can lead to regulatory action by SEBI, including penalties for non-compliances with insider trading regulations. The STD is a critical compliance tool during the investigations and audits. Today, the SEBI has the investigation process of the SEBI has been reached to even the friends who are becoming social media like Facebook and all. So, as a company secretaries and professionals, we should play a vital role in dealing with these aspects and also guiding the corporates to ensure the compliances. In the light of crucial role of company secretaries plays this legal and procedural aspects, the fifth session under the umbrella of EEE 5.0 Master Knowledge Series is scheduled today to discuss technicalities on this topic, and we have with us very, very experienced and eminent experts like Sanjay Burao sir from SEBI and Mr. Manish ji, Mr. Vishnu Gupta from NSE, and our own mentor guide, Madam Savitri Parekh, compliance officer and company secretary of Reliance Industries. So friends, these 2 hours we will be, having a lot of new learnings, new thought processes, and taking up this challenging task as a compliance officer in corporates. With this, friends, I would like to now introduce Sanjay Burao, CGM of SEBI. He is currently working as CGM, Surveillance Department in SEBI, and he is a management postgraduate. During his tenure in SEBI, he has worked across several departments such as equity and debt market investigation, surveillance regulations, and market regulation. He has also served many policy making, served as a member of many making committees in the SEBI. Now I would like to request him, sir, would like to request you to give a brief note and key remarks on the topic, sir.
Okay. Thank you so much, Mr. Ramana. Am I audible? You can hear me? Hello?
Yes, sir. Yes, sir. Absolutely. There is no.
Thank you so much for the gracious introduction. It's a pleasure to be here today amongst all of you. SEBI looks forward to such interactions with the market participants, with the company secretaries on a regular basis, so that we get a broad feedback on how our regulations are getting viewed in the market. Is there any scope for improvement? Is there any scope for giving some more clarifications, etc.? So I have my colleagues with me also today, Mr. Vijayan, DGM, as well as Mr. Javed, AGM. So they would also be around to help us through the discussions today. And if there are any queries which you may seek or you may want to be clarified from the regulator, we'll be more than happy to address such queries. Coming to the topic today on SDD, as you have already pointed out, sir, the SDD came into being for the first time after the recommendation of the Fair Market Conduct Committee in 2018. Some very specific points were made by the committee towards this SDD, and the reason for it, I'll just quote so that it's clear to all of us. Once the UPSI is shared for legitimate purposes, the company loses control over further use. If such information is misused, it becomes difficult to establish a connection between the company and the recipient of information. It would thus be prudent to have a physical or digital trail of information flows of such legitimately shared information. Therefore, the company and the market participants should be required to maintain an electronic record containing the name of the person with whom the UPSI is shared and the nature of such UPSI. So the broad flavor and the intent was given by the Fair Market Conduct Committee that we should have some digital database which should be available in future in case there is any need for investigation or more importantly for monitoring compliances. So based on the recommendation of the Committee on Fair Market Conduct, Regulation 3.5 came into effect on April 1, 2019. And this regulation mandated the requirement of an HDD. Thereafter, based on market feedback as well as our internal review, on 17 July 2020, there was an amendment to the regulation. The amendment stated as under, in order to bring further clarity and to include details of the nature of the UPSI, persons who have shared the UPSI. See, earlier it was person with whom the UPSI was shared. Now we are completing the loop and also requiring the name of the person who has shared the UPSI to be made as a part of the HDD, specifying the internal maintenance of HDD and make the requirement mandatory for intermediaries and fiduciary. So we made a slight change in the regulations in 2020. And again, apart from regulation 3.5, in the regulation 3.6, we prescribed a period for the preservation of such information. So the period was 8 years or till completion of any enforcement proceedings if there were any. So that this can be used as evidence in case we want to bring out any enforcement action. And recently, with effect from June 2025, pursuant to the board meeting held in the first half of the year, we specified a time period for the entry in HTD as well, because there is some lack of clarity as to within what time period should a company incorporate the information regarding UPSI into the HTD. So we said 2 calendar days should be given for the company to make the entry into the HTD. Now, what was the rationale for HDD? Why did we insist that there should be an HDD? It was twofold. One was for SEBI. Second was also for the company. And why did SEBI require the HDD? 4 reasons. Whether a person is in possession of UPSI during the period, it will help us to find out that. Who has shared and received a UPSI? What is the time and details? Was the information shared and received for some legitimate purpose? And more importantly, whether trades were undertaken while in possession of such UPSI. So this was the fourfold rationale for SEBI to specify the requirement of the HDD in the regulations. From the company's point of view, the HDD would make things slightly more simpler for them. So thanks to HDD, the company can track the flow of UPSI and ensure that the price-sensitive information is shared only for legitimate purpose and it is not leaked to anyone. So compliance and monitoring become more simpler for the company under question. So what are the requirements of HDD? What is the information to be maintained? The name of the person along with the PAN or any other identifier who has shared or received a UPSI. And what is the nature of the UPSI? This has to be captured in the HDD. It has to be maintained internally by the company. It should not be outsourced. There should be time stamping and audit trail so that further compliance and monitoring is facilitated. And as I said earlier, it should be maintained for not less than 8 years. As per Regulation 3.5, the responsibility of maintaining the HDD falls on the board of directors or head of the organization of every person who is required to handle such UPSI. So it's a very top level compliance requirement which we have put, having regard to the importance and the criticality of maintaining such price sensitive information. And we have taken several steps in our long journey towards monitoring this HDD. We started with extensive training programs, which we conducted along with the exchanges for the listed companies. We involved industry bodies as well. After conducting training programs, we started by doing some inspection. We started with the top 100 listed companies by market cap. SOPs were put into place. Circulars were issued by the exchanges, including for intimating what are the SOPs for ensuring the compliance. And based on market feedback, from time to time, the SOPs have been revised. Quite recently, we required verification of SDD compliance uh, in as much as what we said was the listed entities are required to confirm the compliance status in the annual secretarial compliance report. And this format was specified in our master circular dated November 11, 2024 under regulation 24A2 of the LODR regulation. So we have tried to integrate it with the CFD master circular. And in case where the secretarial compliance report is not applicable, then the SDD compliance certificate can be given by a practicing company secretary and it has to be submitted to the exchanges annually. So this is how we mandated that the HDD compliance should be verified. Now, if there is non-compliance, what are the steps which we have been taking? So far, it has been largely a soft touch monitoring. For example, under the get quote page of the exchange website, wherever the quotation or the stock price of a particular script is required to be given, now the exchanges have a facility that it is displayed that the company is non-compliant, along with the name of the compliance officer. So if any shareholder of any prospective investor goes to the get quote page, suppose he wants to do some transaction in a particular share, you would immediately know that the company is not compliant with the HDD requirement. So this is more in line with our philosophy of disclosures that let people know, persons know, let the investors know what is the degree of compliance or non-compliance which a company is doing with the regulatory requirement. Then we have also required the exchanges to carry out inspection for verification of the HDD after receiving confirmation from the active non-compliant companies. So if the company is not present at the registered office, the exchanges can initiate steps for suspension. But if the company is available at the registered office, still it is HDD non-compliant, then the exchanges do not provide any further listing approval for any new stock which the company is listing, except for bonus and splits, because these are automatic corporate actions, bonus and split. So there is no further requirement on listing, it happens automatically. But if there's any new capital, either rights issue or preferential issue, and the company is HDD non-compliant, then the exchanges do not provide any further approval. For companies which are suspended from trading, and if they want to seek revocation, then the exchanges take a confirmation of the compliance status, then only they consider revocation of security. And in extreme situations where we feel there is a blatant violation, administrative and enforcement actions are initiated. So this was the broad overview of the HDD. The reason why we introduced in the first place, our expectations from that, and what we expect from the practicing company secretaries going forward. So with this, I hand it over back to the Ms. Jain. Now you can continue the session. Thank you so much.
Thank you very much, sir, for your wonderful insights and especially the regulatory perspective about this PIT regulations and importance of SDD. Thank you very much, sir. Sir, we also request you to, if possible, stay back with us for any queries that can be coming from the members to clarify that.
Absolutely, I'll be there. I'll be there.
Yeah, thank you very much, sir. Now, friends, we will move on to the next speaker, who is from National Stock Exchange, Mr. Manish Dio, sir. Mr. Manish Dio is currently working as an Associate Vice President in the investigation team of NSE. He is a very skilled professional with a strong background in capital markets and financial services industry, specialized in fraud investigations and trade surveillance and fraud risk management. With close to 20 years of experience, he has successfully led engagements related to investigations into fraud and market manipulations. And he holds a MBA in finance and he is a member of a CMA Institute. He is having qualification of CMA. This brief introduction, I request you to take the session forward, sir. And we want to have a more practical aspects into this session.
Thank you. Thanks a lot, Ramana sir, and thank you for the introduction. Good afternoon, everyone, and very pertinent points raised by Sanjay Purao sir. we would like to share from a exchange perspective what are the various points we come across and overall related to PIT regulation as well as SDD compliances. We have a short presentation. I will just share my screen. Just let me know if
Surbhi, access is there, no? To share the screen.
is it visible, sir?
Yes, sir, it is visible.
Yeah, okay. So, right. Now, these are some of the snippets in the media just to show uh, how there has been an increased focus on PIT regulations and insider trading cases, how they have been detected, how SEBI is initiating action against companies in terms of, say, SDD non-compliance or PIT regulations violations. So these are some of the instances which we just wanted to showcase. There have been quite a few settlement cases also, settlement orders also. You can go through them, all of you can go through them from the SEBI website. And those will provide some great insights into the topic. So yeah, coming to the next part. So why insider trading is such a big problem? Because because of the fact that it creates information sorry it creates information asymmetry. It does not create a level playing field for all investors, and since some people are misutilizing the uh, insider information that they have, it is considered an illegal practice across the world. So uh, I may not get into the theoretical or definitions part as such, because those have already been covered by Ramana sir in his yeah, in his session, or whatever he has covered. So these are some of the key terms within the PIT regulations. One is UPSI, unpublished price sensitive information, insider, connected person, and deemed to be connected person. Now, the base of this is LODR requirements, Part A and Part B. In Part A, the what should be the companies disclosing as events. First part in Part A, it is covered that without any application of guidelines of materiality, that is Part A, and Part B specifies those disclosures uh, which apply the guidelines of materiality. So in the first case, it includes senior management changes, changes in RTA disclosures, shareholders, etc. Whereas in other case, there it applies materiality as a concept, because there can be certain which are subjective. So there can be commencement or postponement of commercial production, addition of capacity, product launch, etc. Yeah, so just a small mention of UPSI. UPSI is what is unpublished, or that is not generally available to the public, and it is likely to affect materially the price of securities. And it includes financial results, dividends, bonus issues, changes in capital structures, mergers, acquisitions, etc. So this basically clarifies what UPSI is. And there recently there have been the UPSI definition has been expanded with certain key elements being included, like say changes in ratings, then fundraising proposals, then agreements which may impact the management or control of the company, frauds or defaults by the company, its promoters, KMPs, etc. Then initiation of forensic audit. So related to that, the same point, there can be initiation of forensic audit related to, say, detecting misstatement in financials, misappropriation, siphoning, or diversion. Then there would be something related to resolution plan, restructuring, or one-time settlement. admission of winding up a petition, then regulatory actions, orders passed. There could be some litigation or disputes. So all of these have now been included under the gamut of UPSI definition. So I would call upon my colleague Vishnu to share some insights on UPSI maintenance and STD.
Hi, good afternoon, one and all. And Ramana sir, thank you so much for the introduction. And Sanjay sir has already covered very extensively on the overview of the
Vishnu sir,
STD. Yes, sir.
sorry for interrupting you, sir. I would like to give a brief introduction about you. I
Sure, sir.
thought
Please go.
Manish sir transfer to me.
Okay, sir.
Friends, we also welcome Mr. Vishnu Gupta sir. He is currently Chief Manager of Investigation Department in NSE. He is MBA in Finance and also Certified Fraud Examiner, ACFE, and NISM Certified Anti-Money Laundering Manager. He had started his career in 2006 in investigation and reconciliation of multi-currency disbursements with Citigroup Global Services. He has been part of multiple regulatory functions in NSE, such as investor grievance services, enforcement, delisting of shares. He has also attended more than 100 investor awareness programs conducted by NSE across 12 states of Eastern India for spreading financial literacy. Sir, thank you very much, sir, for having you. Manish sir, thank you very much for your insights, brief, updates about the SEBI changes in the regulations, the regulation, UPSI definition especially. And please be there, sir. And we will to state that ICSI has released one publication in the year 2023 on manual compliance certification for the practicing company secretary. Sir, Vishnu sir, you can take it forward. Sorry for interrupting you.
No, sir. Thank you, Ramana sir. Manish will continue after I am done with the bit.
Sure.
And I just wanted to state again that Sanjay sir has very extensively covered the overview of SDD and the genesis along with the regulatory overview. So I will. Can you all see the screen?
Yes, sir, it is available.
So I will start. I will not touch upon the points which are already covered by Sanjay sir and my colleague Manish. I would just talk about it from the exchange point of view and things which we think should be discussed now. So why was this STD introduced? So in operational terms and from regulatory point of view, if you think, we need to understand that how UPSI is being controlled by the company, because UPSI is supposed to be on need to know basis. If say a company is embarking into a project which is something to do with their accounts and finance, then a team member from the business development is not required to be aware of it at the initial stage. So this is how probably this is the genesis of why a UPSI is required to be maintained in SDD, so that we have the audit trail. We know who all had the access of the information, who has shared the information with whom. So these there are compliance and regulations which are being built around the ecosystem of this, and there should be enough internal controls and checks. So this is already covered that name of the person and PAN is required to be recorded, who is sharing the information and who is receiving the information. System requirement, if we see in this slide, so there are various systems now available in the market. Various well-known RTAs are have come up with their softwares. There are some companies which are very, they have given useful tools to in the market for recording of STD and to control the movement of UPSI. These tools are very good enough. They ensure that adequate checks are in place, including time stamping, audit trails, so that there is no tampering of the information which is already recorded in the STD. So we have tried to build based on our exchange experience, we have tried to build, this is a hypothesis, hypothetical example, wherein, say a company, MD of the company captivates with an idea of applying for a tender, and he discusses the same with his internal teams, relevant teams, for applying the tender. And somewhere on the day 5, they decide that which team should be participating in this tender, and the approval is in the place. Say board approvals which are required or internal approvals which are required, that have been taken. Submission of the bid to the competent authority, then letter of intent is received by the competent authority, and then when they receive it from the say the company who has passed the tender, they intimate to the exchange. Now what we have experienced, there are some companies which would start maintaining SDD from day 3. That is when the MD is discussing the matter with the relevant teams. There are some companies which start maintaining the SDD from day 8, when the required approval has come, from their internal approval has come. Again, there are companies, I wouldn't say what percentage of companies, because we don't have that universe with us. However, there are companies, they just give us a 1-day SDD. They say that we came to know about this only 1 day prior to the announcement given to the exchange. So these are some of the we have tried to build the example based on the exchange experience. Another experience that we want to share is we receive SDD on in various formats. However, all the requirements which is given by the SEBI is maintained. Along with this, we receive in. I am sure this is not legible, so I would read out. Say there is a company one, and this is the actual. Format that we have picked up from one of the company's response. The first is UPSI ID, then recipient name and ID, recipient PAN number or any other identifier, informant name and ID, informant PAN number, nature of UPSI. This nature of UPSI is very helpful for exchange. Purpose of sharing, date and time of sharing, then sharing till what time, mode of sharing, medium, remarks, whether non-disclosure agreement was signed or not, date of first entry with the username, last modified, and date and time. Now, second is the different type of format. What they have done is they have bifurcated that information is shared by whom and who has received the information. And all the other details which were in the previous format is there. Another, a third type of a format that we receive is that is very minimal information is given to the exchange. This is not to say that companies are not maintaining or not sharing with the exchange. However, this is how they were maintaining, but we would urge them to ensure that the maximum information that they can share with the exchange in this regard should be stored in SDD in a digital format, because as it has been discussed earlier by the eminent speakers, that these information may be required for any further investigation. So at times what happens, that lack of information may also lead to a potential suspect becoming a proper suspect. However, if I have the proper information, then we would be able to pinpoint to a suspect who is probably has taken the unfair advantage of the UPSI if he had the access. So that is one requirement. These are some of the issues that we have picked up from the actual SDD responses that we have received from many companies, including some of the PSU companies, some of the very well-known companies. We will not be discussing about the name of the companies, but mostly 3 to 4 issues that we see is that companies seek extension on the very last day of the deadline. Second is there is ambiguity in response. Say companies say that this order announcement is not considered as a UPSI, but why it is not considered, that is not given. If a company is saying that ordinary course of business, then we have seen, say a order of 4,000 crore has come this time, and previous all orders were less than 1,000 crores. Then as an exchange, we would understand that this is a milestone order, and we would want we what we think is that being a milestone order, this is a material information, and this should have been captured under the SDD, considering it to be a UPSI. However, companies say that we have not considered it as a UPSI because it's an ordinary course of business. So this is something we would urge the all the participants to please revisit your policies of how you are identifying an information to be a UPSI or not to be a UPSI. Because if there is a huge movement in the order size, then I think you need to take it back to your board, to your senior management, and discuss and again make relevant changes in your policies. That is one. Third is reasoning. When we see when you are saying that this UPSI is the general information, however, you are making an announcement on the exchange. So whatever announcement that you're making on the exchange may not be considered as general, because there's a lot of this information is being accessed by many people. Investors, your investors are also accessing this information, so they are not understanding whether you are considering it as general or not general, and we also don't understand that why are you saying this as general. So if you give us some info like this is a general information, then a one liner or a brief on why you are saying it is a general information, that will help exchange in understanding your point of view also. These are some of the best practices or compliance checkpoints that you should maintain. This is already discussed, but we are just reiterating it. The slide is self-explanatory. However, capturing the information, also recording the transmission whenever it is going out of the organization, nature of UPSI to be captured, PAN that we have discussed. Yes, this should be maintained at least for 8 years. This is also mentioned in our exchange circular also. Second important point is that this activity should not be outsourced, because this is a very confidential information. This UPSI, since we are saying it is a UPSI and we are maintaining an SDD, they should be given that we should give that benefit to it, and should not be outsourced. Non-tempering, as I mentioned earlier, that there are various tools available in the market which ensures that proper audit trail is there. Even if you are making some changes, that also should get captured, and this should be maintained in your internal servers. And now I would request Manish to kindly take it forward. Thank you, sir. Thank you all.
So yes. So some insights into how insider trading can be prevented at various levels. One is at the regulator, that is SEBI. Other is at exchange level, and third is corporate level. Now at the SEBI level, they have already framed effective regulation, and there have been tireless efforts from their side also. And also there have been instances where action has been taken, as was shown to you in the first slide itself. Now, what is the exchange role? Exchange need to have effective surveillance and investigation capabilities uh, to to detect cases of insider trading, so that they can be taken to the logical conclusion. In terms of corporates, they should be strengthening the policy framework and have proper control mechanism, adopting best practices, as we have, as Vishnu just explained. So these are some of the levels how we can prevent insider trading at various levels. Now, I'll just explain to you one role that exchange plays, and this is also an initiative by the regulator, that is SEBI. So what we generally do is that we receive from the listed companies, share list of designated PANs and period of trading window disclosure to the depositories, that is NSDL and CDSL. Then NSDL and CDSL are for providing that front end to get the data and getting the integrated data from companies. They in turn share this information or list with the exchange, and also they at their end they freeze the demat account for the trading window period. And at exchange level, that is NSE and BSE, we get once we get this data from depositories, we also freeze the trading account for the specific period for the specific script. So what are the benefits of this? So earlier what used to happen is that there were inadvertent or unaware behavior that could not be controlled, which is now addressed by this specific mechanism. Then there almost 3.5 lakh pans on any given day are restricted from trading. Insiders which are already known to the companies and everyone, those are debarred during the debarred to trade during window closure. So it has led to non-compliance, a lower rate of non-compliances. It has reduced risk for the listed companies, and as pans are frozen, there is no penalty as such, because that is one activity that is complete or that has reduced to a large extent. Now, this is a system which is currently only applicable for financial results for all companies. Now, what are the regulators' expectations from companies? That the key expectations are that all UPSI is identified, and all employees who have access to UPSI are identified. Then there are appropriate restrictions on communication of UPSI. There are appropriate controls and strong policy framework related to UPSI. Plus, it should be reviewed periodically so that the framework can be strengthened on a periodic basis. Sensitizing employees or educating them who those employees who are new, generally they are not aware that this is UPSI, or they do not have in-depth knowledge. So it is expected that they are sensitized and various protocols are kind of they are made aware of certain protocols for handling UPSI. A list of designated persons, and it should be updated on a periodic basis. Now, the importance of this regulator's action can be seen in the below tables. One is related to insider trading complaints received by SEBI. In 2021-22, they were 119, which reduced a bit to 101, but now it stands at 151 for 23-24. Similarly, insider trading investigations completed by SEBI are were 48 in 2021-22, rose to 75 in 22-23, and now it stands at almost 2.5 times or 3 times, which is 130 for 2023 and 24. So these are some of the indicative best practices, which most of which have already been covered, like using encryption, DLP policy, access controls, then secured and separate workspaces, official email platforms, setting up Chinese walls wherever necessary. So all of these are some of the indicative best practices that companies may want to adopt. These are some of the cases, recent insider trading cases, and especially in the case of B, the second case, which you can see on your screen. In this specific case, the relationship was established by SEBI on the basis of call records, since party A and party B were connected because they were discussing marriage proposal of their children. So that is an interesting case. If you want to, you may want to go through that. This is a recent one. Plus, one thing to ponder, there was a case in the United States, SEC versus Matthew Panuat. So in this case, this person was a business development executive at company A, and he understood that Pfizer was taking over the company. So he entered into out of the money short-term call options in company B. So this is known as shadow trading, in which and he earned a profit of more than one lakh dollars in this specific case, and SEC charged him for insider trading violations. And since so this is an interesting case which we can all think of. I'm not giving any judgment as such, but you can go through this case. So these are kind of passing thoughts from our side. We are ready to take any questions which you have. Thank you.
Yeah. Thank you very much, sir. Friends, we also have with us today Mr. Vijayan sir, DGM of SEBI. Sir, Vijayan sir, do you want to share your input, sir, inside? Then we will go to Savitri madam.
No, thank you for inviting. I think our CGM is already there and he has already given an overview of this SED and what are the requirements that needs to be maintained.
Sure.
I think we'll continue with the program. Questions, anything we'll take up at the end of the day.
Thank you very much, sir. Friends, now welcome Savitri Parekh madam, very experienced senior most professional. I would like to give a brief introduction of though it is not required. Savitri madam has 30 years of corporate experience and is currently company secretary and compliance officer of Reliance Industries Limited. She is the chairperson of governance committee and co-chair of legal affairs committee of the Bombay Chamber of Commerce and Industry. She has also been member of few working groups constituted by SEBI, a recipient of Chevening Scholarship for Young Indian Lawyers, which is fully funded by the Foreign Commonwealth Office, UK, and get exposure under in European laws. Madam, actually, your profile will go long time, but to cut short, we have made it brief, madam. And I request you to please take this session.
Thank you, Mr. Venkatramana. It's indeed a pleasure to be addressing our participants once again. It was very beautifully explained by Mr. Sanjay Purav, and he has set the stage for the rest of us. And of course, both Manish and Vishnu have covered it pretty exhaustively. And therefore, my job has been made pretty easy. As Mr. Vijayan said, that it has already been covered. So what I'm actually going to cover are few points in general with respect to PIT regulations, after which I'm sure there would be several questions which all of us would be happy to answer. One of the common questions that I'm often asked at seminars is one of a distinction between a connected person and a designated person. Or let me put it in a more simple term. Let's assume a very senior person in an organization superannuates. Is it necessary to treat the person as a designated person for another 6 months, because the law says that for 6 months a person would be a connected person? Let me answer this and say that the moment the person superannuates, he ceases to be a designated person, because the term designated person is very clearly covered in Regulation 9(4) of PIT regulations. So the moment he superannuates, he is no longer a designated person because he is no longer in the employment of the company. Now, let's assume he superannuates and after 10 days he wants to sell the shares of the company which he had purchased, let's say, 2 years ago. If it was ESOP, it is different, which is the reason I'm distinguishing. If the person wants to sell, will he be free to sell because he's no longer a designated person? Here the catch is he is a connected person, and if he was handling any sensitive work, if that unpublished price sensitive information is not in public domain as yet, in which case his name would have gone into the structured digital database, and he would be deemed to be a person who's privy to some information which is there in the structured digital database. Therefore, he would be treated as an insider, and he should not be dealing in the shares of the company. In fact, I would go one step further and say, from a conservative perspective, it is necessary that designated persons are told not to deal in shares of the company, shares and other securities of the company for a period of 6 months, because they would be treated as connected persons for a period of 6 months. Let me take this practically to one step further. All the companies now are required to give the details of designated persons to the designated depository. Is it necessary to give the name of this person and continue the name of this person for a period of 6 months? Answer is no. The name of such a senior person would be removed from the list which is given to the designated depository. But since the person continues to be a connected person, he or she should not deal in the securities of the company. This is basically because he would be treated not as a designated person but as a connected person. With the term connected person, is connected to some kind of unpublished price sensitive information. Of course, it is possible that a person ceases to be a designated person and deals in the securities, but he is not a connected person, because with respect to that particular unpublished price sensitive information, he was not involved at all. I would not really go into those nitty gritties and say that from a conservative perspective, please tell all your designated persons who superannuate or resign, leave the company, tell them not to deal in the securities for 6 months, but remove them from the list of designated persons, because they cease to be designated persons. If you keep them in the list of designated persons, after you remove their name for 6 months, they would still have that particular shadow of connected person. Hence, remove their name from the list of designated persons. Moving on to the next point, contra trade. Contra trade is one which one needs to be very careful. In fact, I saw on the slide that was presented by Manish as well as Vishnu, they also had covered this point on contra trade. If any designated person, even by mistake, trades in very small quantity, let's say 10 shares of the company, and within 6 months has an opposing trade, then it will amount to a contra trade, and there is absolutely no escape from this unless specific pre-clearance has been taken from the compliance officer, which the compliance officer would be able to give only for bona fide purposes. Obviously, it can't be for 10 shares then. Let's say, for example, a person had bought shares and unfortunately is now required to liquidate the shares to pay for an urgent medical treatment. Please give pre-clearance because it's a bona fide purpose. At the same time, when you give pre-clearance, also see whether there are other liquid funds available with the person so that you can talk to the person and take it forward. If it is for pledge of shares, for urgent medical need, he needs to pledge the shares, he doesn't want to sell the shares, fine, but find out the purpose and only then give pre-clearance, because pre-clearance is not to be presumed. You have to be sure that it is for a bona fide purpose. Only then should the compliance officer give pre-clearance. Let me move on to something which is very, very important, and I always talk about it, which is portfolio management scheme. People often mistake these portfolio management schemes as ones which are outside the purview of PIT regulations. Let me caution and ask all compliance officers on the call to specifically create awareness within the organization and ensure that all designated persons and all persons who have anything to do with securities, who want a better understanding of PIT regulations, are clearly made aware that PMS is not outside the purview. Let me just explain this in a minute. When you enroll for a portfolio management scheme, the portfolio manager has one designated demat account into which the shares originally would be credited, from which all the members, let's assume there are 20 persons whose DP accounts are linked to this portfolio manager's account, all 20 of them would then get the shares credited to their demat accounts. It would be a separate demat account of this person, but it is the demat account with the PAN number. And typically, when you look at the PAN number, it will get linked to that particular person. And if he is a designated person, unfortunately, sometimes during window closure period, few shares may get credited or may get debited because the portfolio manager may have either bought or may have sold the scripts of the company, which should not be done. Fortunately, now, since there is freezing at the ISIN level, it does not happen with respect to designated persons. But as we speak today, this risk is there with respect to immediate relatives of the designated persons. And I'm happy to say that by circular of 21st of April 2025, this particular point has also been taken up by SEBI, and therefore effective from July 1st, the effective July 1st, this particular depository, the designated depository, will also take details with respect to immediate relatives of the designated persons, and the ISIN level freeze will be applicable at that to that set of constituents also, which is a very, very good move and is a welcome proposition, because very often one has this problem of immediate relatives having credits or debits, especially with respect to PMS, which will get completely addressed. This is certainly a very good move, I would say. Immediate relatives getting covered. Also, with respect to connected persons, which I covered a little while ago, the list of connected persons also includes what is called deemed connected persons. And the list of deemed connected persons will also include spouse of those respective persons or any other person for whom an investment decision is taken by the person. So there are two categories of persons who also need to be covered apart from the spouse. One is set of persons for whom the designated person takes financial decisions. The second is the persons on whose behalf you're holding a power of attorney and you're executing those. So you need to be careful that all these persons also are brought in, who's financially dependent. And in fact, which is the reason every year you take a disclosure from all the designated persons with respect to any other person who may have borrowed monies from you of a large amount. The next point is on trading window closure. With respect to trading window closure, PIT regulations now have a clear period. It says from the first of the month following the end of the quarter till conclusion of 48 hours from the end of the end of the meeting, at which financial results are considered. So therefore, this has now become fixed. Earlier, there were different varying periods. For that matter, even today, there are varying practices. Few companies do this trading window closure period from before the end of the quarter. Few others do it from immediately after the end of the quarter. So, and going by PIT regulations, it's absolutely fine, even if it is after the end of the quarter, but it starts from the first of the month following after the end of the quarter. The recent circular of SEBI with respect to amendment to the definition of the term UPSI is also important. Effective June 2025, 10th of June 2025, these amendments will come into play, where the term unpublished price sensitive information now also includes few of the uh, few of the instances which are covered in Schedule 3, Part A, Para B also, and few of those from Para A. Suffice it to say that most of those points have got covered. With respect to Para B, Schedule 3, Part A, the concept of materiality has also been brought in very clearly in the definition of unpublished price sensitive information. This is, of course, an inclusive definition, but in case there is any of these transactions are likely to move the price in a material manner, it becomes an unpublished price sensitive information. Of course, with respect to SDD, which has been the main focus for today's discussion, with respect to information which is emanating outside the company, the SDD cannot be prepared before. So therefore, SDD will be required to be done within 2 working days, within 2 days of the receipt of the information by the company. So therefore, in such cases, the post facto entry in the SDD is what is required to be done, and 2 calendar days, not 2 working days, 2 calendar days from the time of receipt of the information in the entry in SDD will have to be made. Also, UPSI, which does not emanate from within the organization, trading window closure is not required to be uh, observed. I would also like to speak on trading plans. Regulation 5, which is a very simple single regulation, uh, deals with trading plans. A lot of flexibility has now been brought in effective September 2024, whereby the person who's giving a trading plan can also give a conditional trading plan. And the condition is only with respect to price, and the range which has been provided is plus minus 20%, which means if you are buying shares, or rather if you want to buy shares and you're giving a trading plan, then you can give an upside of not more than 20%, which means if the price goes beyond 20%, you will not be able to buy. Even if you're agreeable to buy and you feel the price is okay, you cannot give effect to the trading plan, because there has to be some certainty as to what you're actually filing with the stock exchange and your actual actions. Similarly, with respect to sale, you can say that you do not wish to sell if the price falls below a certain price, which certain price cannot be minus 20% of the closing price of the previous day when you give your trading plan. So if it falls below the 20%, certainly is a good price, but you will not be able to buy because, I'm sorry, you will not be able to sell because you have said that that is the benchmark price below which you will not sell. So you cannot change it. However, if it is within the range that you've given, you will be bound to do it. A trading plan will be irrevocable in the ordinary circumstance, except if you have given a conditional one and the price is beyond the range. If you are buying, if it is beyond that 20% range which you had mentioned, if you are selling, if it is below the 20% range which you had mentioned. Other than that, it is very much binding on you. This is a good move because, in case a person is not very sure and does not want the market to be like during the pandemic, we did see where people found it difficult to give effect to their trading plan, or at least there was concern, and there was always concern as to whether it would be binding no matter what the price be. So this has been provided in the law itself, in the regulation itself. The next point is on pledge, gift, any other kind of transaction. Now, trading, the way it's been defined in PIT regulations, it's very, very broad. And trading would include any kind of transaction which causes a change in your holding in the DP account. To put it very simply, I would look at it as a plus or a minus. Anything which causes a plus is an acquisition, anything which is a minus is a disposal, and please ensure you comply with PIT regulations. So, pledge, gift of shares, all these also require compliance with PIT regulations. There was often a question as to what should be treated as the value for the purpose of gift. Should be the market price, because anyways we are referring to scripts which are traded, and you do have a price point which can be used to compare the price. And based on that, 10 lakhs per quarter is what actually requires pre-clearance. Disclosure with respect to designated persons has automatically become automated. It is now covered under the system-driven disclosure, which is also SDD, but not the structured digital database as we understand SDD. The system-driven disclosure automatically captures and it populates the stock exchange site with respect to the system-driven disclosure details. And pre-clearance, however, is not done away with. So pre-clearance will very much be applicable even with respect to transactions which exceed 10 lakh per quarter or such other figure not more than 10 lakhs that the company may have provided in its code of conduct or in its code under PIT regulations. So this is something which the designated persons in an organization will have to be clearly made aware of. ESOPs. ESOPs are not covered by the restrictions. However, even with respect to ESOPs, the pre-clearance provisions will apply. For selling of ESOPs, the provisions with respect to contra will not apply. Let's say, for example, in few schemes, you may have sale to cover, where you are selling to cover to be able to subscribe to be able to exercise the grant which is given to you, in which case you would be selling so as to get the money to subscribe to the new shares which would have got vested. So that's permitted provided you have not dealt in the market at all and it is only ESOP holding that you have. So if you have, the FAQs very beautifully show this by means of a chart. So if you have not bought or sold shares outside your ESOPs, then you will be entitled to this benefit. But even if you have bought one share, the contra provisions will become applicable. One can possibly argue and say that, look, I didn't sell my ESOP shares. It was the share that I bought from the market. Sorry, that ground will not work. If you have bought even one share, you will lose the shield that you otherwise get with respect to ESOP shares. I think I would stop over here and all three of us could take further questions. In fact, all five of us can take further questions from the participants, because PIT regulation is one where there are a lot of questions, and while we can go on and on, it will be good to take questions. Over to you, Venkataramana.
Yeah, thank you so much, madam, for wonderfully explaining how the connected person and designated person should be looked into, and how the window closure and many of the questions also, frequently questions you have covered up already. Still, since the subject is very vast, we have many questions from the participants. I would like to take up one by one, madam. Madam, I think first one is for you. Is it mandatory to make an entry in the SDD regarding the monthly MIS reports relating to profits turnover information, which is given to the managing director, whole-time directors, or internal management circulation?
See, you need to see whether your monthly MIS is material. Like, say, for example, if your quarterly results last year, let's say in a quarter, you have a turnover of, let's say, 100 crore. And on a linear projection, it comes to 30 to 40 crores per month. If it is well within that range, you would say that this is something which the market does not really look at as something very different, and therefore each company may have a policy as to what would be treated as different. Let's say, for example, from a particular region you get a big order, that would be certainly one which is material, and in which case that will require an entry in the SDD. Your monthly MIS, the components of the monthly MIS will have to be gone into, and not just the outcome per se. Let's say, for example, if there are specific seasons when it goes up or something, if it is within the range, I don't think prima facie it is material. However, each company would have its own policy. In fact, this is a question which should be answered by the stock exchange. May we request both Vishnu and Manish to answer this, please?
Yes, madam. I have a continued question to them. Manish sir, actually, does the company need to mandatory trading window during the quarter results preparation for the connected persons and deemed connected persons? If so, are the list of connected persons required to be updated to the designated depository for freezing hands?
Yes, yes, yes. So there are two questions, I guess. On the earlier questions, I would agree with ma'am that if it is material in nature and it shows that there is something which is an indicator, something significant, in that case, the it can an entry can be made into SGD. But otherwise, I don't perceive any reason for it to be included in the SGD. Your question is related to updation of names. Yes, it should be done on a regular basis, and we are doing this trading, debarring pans from trading in the during the trading window closure period, and this data we get from the depositories, which is provided by the companies. So they should be providing. They should ensure that proper and correct data is provided to the depositories, because we have seen in certain cases there have been certain PANs or certain designated persons which should not have been included, but they were included, and which has caused an inconvenience to them as well as the designated person. So
Yeah.
in that
Sir,
sense,
in certain cases, what will happen even after the trading window is closed, the person will dealt with the share without having UPSI in fact in hand, knowingly or unknowingly. So the regulator will look into it, and what the company should take the action on this.
yeah, in that case, it depends on the facts and circumstances of the of each case, and each case would be different. So companies should look at it from that perspective, whether it is a breach of the PIT regulation or not. If it is not, then maybe the company should satisfy itself.
Okay.
Yeah.
Sir, one more thing, just to ask from my point of view, there are, close relatives and all is covered. There are circumstances where even they are not active terms also, the close relatives. So how we will come to know and how we can restrict them from dealing with these?
Sorry, sir, I didn't get your question.
The relatives are covered, no, sir, as per the regulation, close relatives. Even certain circumstances, those relatives will not be even in talkative terms, talking terms with each other
Yeah,
because
yeah.
of the internal disputes, family disputes or something. So how a compliance officer has money, how to restrict them, how to control them in case of transaction?
So I think even if they are not in talking terms or something like that, I think it should be included under this thing, uh, uh, because compliance is a compliance, and it is quite objective in nature. So if there is any kind of violation, in that case, the story would be different. But according to me, it should be as a compliance. It should be included. Uh,
Okay, sir. There is another question, maybe, uh, Sanjay sir may could able to answer. Sir, as per the Insolvency Bankruptcy Code, the resolution professional is under obligation to ensure compliances with applicable laws, sir. Hence, in case of listed entities, all SEBI-related compliances also to be taken care. However, is not much, no much clarity or guidance for the compliances of SEBI regulations, and SEBI is non-responsive to any queries raised by RPs, leading a vacuum in compliance management system by the listed entities under CIRP. So SDD compliances is one of such compliances. Can you give any guidance or how to go about it, sir, by the resolution professionals? Any special guidance can be get on this in this regard?
If the resolution professional, can you hear me?
Yes, sir. Yes, sir.
Yeah. If the resolution professional comes to us with a specific query on where is the finding difficulty, we'll be glad to address it. So far, we have not got any such inputs or any comment or clarification being sought from any RP. Because moment an RP is appointed, he becomes de facto in charge of the company. So he is responsible for ensuring compliance.
Okay. Okay, sir.
So I don't think there should be a problem. If there are any specific pain points where he feels that these things cannot be completed, he can come to us and we will sort the matter out.
Okay, sir. So regular write the information or seek a clarification from you in the regular window and take the guidance.
Definitely, definitely.
Thank you very much, sir. And another question, if any KMP resigns, madam, can you please explain if any KMP resigns and on the same date their resignation is intimated to stock exchange, is it still need to be get recorded in SDD as UPSI, madam?
So actually, the definition of UPSI is very, very clear. There are two components. One is any information relating to the company or its securities. Here it is relating to the company, which is directly or indirectly likely to materially affect the price.
Okay.
So, by the resignation of the KMP, if there is likelihood of a material effect on the price, let's say, for example, the KMP is one of the directors of the company, a whole time director of the company, or the managing director of the company, whose exit is likely to affect, then definitely SDD provisions would get attracted. It will not be from the date of intimation to stock exchange, because the guidance note on regulation 30 of LODR very clearly says it will have to be given on the date of resignation, that is on the last working day. And last working day and date on which the person may have expressed his desire and would have said he is resigning, there would be a gap. In that gap, if people were aware of it, that definitely would be treated as a UPSI. Otherwise, if it is the CS, CFO, ordinarily those may not really be materially causing an effect on the price. So, suffice it to say, from a theoretical perspective, from the time the organization is aware of the person's moving out till the time it gets disclosed, if such a news is likely to have a material impact on the price, it would be treated as UPSI. And if it is UPSI, SDD provisions will be attracted. Disclosure happens going by guidance note on the last day. Rightly so, because till the last day there is a lot of discussion which may be happening, asking the person to stay back.
Oh, okay, madam. Thank you, madam. So it both depends on the how it affects the price.
It
That is the
depends
key
on who
factor.
the person is.
Yes.
And the stature of the person is what is most important, because that will then determine whether there's going to be an effect on the price or not.
Oh, okay, madam. Another question, Sir Manish, sir, whether the company has whether any company has entered the names and details of any regulatory officials where the company is under inspection or investigation process as a UPSA, sir.
We have not come across any such case till now.
Fine, sir. And whether should margin trading be treated as a creation of pledge, which would trigger the contra trade violation?
Uh, Yes, if in effect, if it is so, if it is a contra trade by taking a margin pledge, so that there is no reason why it should not be included.
So,
Thank you.
pledge will clearly get recorded in the records of the depository, and it will therefore be considered as trading for the purpose of PIT regulations, because it would be considered as a disposal under insider trading regulations. Yes, therefore it will be included. Margin trading is purpose for doing the pledge is for giving it as a margin. That purpose is not relevant. The action is what is relevant, and the action is one of creation of pledge, which requires all the compliances. So, therefore, if it is within a period of 6 months, contra provisions will also apply.
Irrespective of whether it is invoked or not, pledge is invoked or not.
Absolutely. Invocation of a pledge is a completely different transaction. Creation of pledge is different.
Okay, madam.
Invocation is because of a default that the pledge gets invoked.
Okay, madam. And the next one is.
But let's also take the views of the regulator on this, please.
Yeah. Sanjay sir.
Yeah, I think Vijay and Javed, you all would like to chip in because it's an operational level issue. Vijayan?
As of now, since it's considered as a trade, right? So then it will attract contra provisions.
Fine, sir. Sir, I have one more continuing question, sir. In case of a company which has filed DRHP, which is not even at listed, in such case, what type of information to be captured in SDD, sir? Vijayan, sir.
Sorry, I didn't get the question.
Yes, sir. In case of company has filed DRHP, which is not yet listed, in such cases, what type of information should be captured in SDD?
SDD, see, whenever the SDD is applicable, whenever a UPSI is coming into and whenever a company has an information which is likely to be a price sensitive information, which will be affecting the price. So if it is going to be listed company, it has to be ready with the SDD. May not be information, may not be some prices information they have already with them. Then it has to be entered, because as soon as it gets listed, all the applicable regulations under PIT will be applicable. So they has to be ready. And if you remember the earlier presentations, there was one condition is there for listing approval, that SDD company has to be having the SDD, then only they will get the listing approval from the exchange.
It is irrespective of well in advance before even the issue is getting opened.
Yes.
Thank you, sir. Thank you. Can a promoter, sir, Manish sir, can promoter transfer shares among the other promoters received being nominee of deceased in the same year, or either by way of gift? Will it also be treated as a trade or transaction?
So this is through off market, you are saying?
Off market, yes, sir.
Yeah, I don't see any reason why it should not be treated, because it can be, say, transferred to anyone else, and then someone can dispose of, and so it can be it's just adding one level. But maybe I think Savitri ma'am or Sanjay sir would be able to throw more light on this.
It is a transmission, sir, in fact. Actually.
Transmission is outside the purview. Transmission, based on the probate or will or otherwise, will not be considered as a trade, because it is not a transfer inter vivos. You're just giving effect. And in any case, the transmission, if it is done, even under LODR, it very clearly says that if it is from one of the promoter group, then the legatee automatically becomes part of the promoter group. And there's also an informal guidance with respect to one of the UP based companies. Yeah.
Irrespective of whether it is through nomination or otherwise.
Yeah. Whether it is nomination or it is through the will, it is one and the same. It's a case of transmission. If it is transmission, then you don't have to see trading window closure also, because it is, the same restrictions will apply. Instead of Mr. A, it goes to Mrs. A, and Mrs. A will have to then hold it in her name as the person who's got it by way of transmission. But gift is different. Transmission is different. Sorry?
But gift is always different.
Absolutely. Gift will be covered under pre-clearance, and all those provisions will certainly apply.
Thank you, madam.
We can
The
also
next
ask Mr. Sanjay Puravji, or we can also ask Mr. Vijayan in case they have any comments.
No, madam, you're perfectly right. There is this difference. Transmission is obviously exempted. And the way we are looking at transmission is different from the way we look at gift.
That's
So
fair.
your interpretation is spot on. Thank you.
Another one is, sir, question, is the regulation is applicable to unlisted public and private companies as well, because the term is used as securities shall have the meaning assigned to Securities Contract Regulation Act. It is maybe relevant to the
Yes, of course. See, actually, even a debenture listed company will have to will have to comply with PIT regulations because the term used is securities.
okay. Next one is
And there's also a clarification that GDRs, ADR will also have the same restrictions.
so another one is, while recording the entries in SDD at the time of internal sharing of UPSI within the organization, is it mandatory to record both the sender of UPSI, recording the details of member whom UPSI is shared would be enough?
This was very clearly covered in the presentation of
Yes, yes.
Mr.
Yeah,
Manish.
yeah.
Please go ahead.
Next question is, sir, NSE is dealing with the entity like Tyranny nowadays. Is there any specific care input on this, sir?
Sorry, I didn't get your question, sir. Entity like?
Entity like Tyranny. Maybe the question is not clear.
I'm not clear about this
Not
question,
clear
sir.
about. Another one is, sir, if any UPSI is generated from within the listed entity, then within how many days companies are required to make entry? Currently, in law, it is mentioned that 2 days of the information. So, what is the exact time?
Yes, it is 48 hours, but it can be made earlier also.
Okay.
And it also depends on when the company is treating it as UPSI, as we had explained it in our presentation. So it is important when this piece of information is treated as UPSI. Within that, after that, within 48 hours, an entry should be made in the STD.
In case of login access, sir, login access is not given to the insider trading software, is given to only designated persons. So employees other than the designated persons who shared UPSI are also required to be recorded in the.
I think Savitri ma'am can throw more light on this because we are not aware about access logins of systems used for STD entries.
Sorry, can you just repeat the question once
It is
again?
login access given to designated person only, no, madam.
So actually, there are different systems where there are different methods by which the entry in SDD is made. One is few companies give login access to all the designated persons to make entries when they get when they get any UPSI. Another is you have certain set of people who only make entries in the SDD. So who has access, login access, what will the access right be, are all ones which can, just as in SAP system, you have different rights given to different people. What is important is you need to see as to how exactly is the audit trail getting maintained, who is making the entry, and can the person who's making the entry get access to the entire file, or is he only getting entry to only getting right to make his own entry. So there are several softwares in the market. I don't know the features of all the softwares, but these are the points which every company secretary should be mindful of, and based on that login access, what does the person get to do with it needs to be seen.
Means internal access, internal control is the main important.
Absolutely.
Okay, madam.
So one should not get access to the entire thing. Then you come to know who are the others who are having this UPSI. Then the need to know basis, Chinese walls, all these have to be respected, and you cannot give it.
And even if employee is not have person but possess UPSI, details also we will need to enter, madam, in the database.
Sorry, come again. Person is not
If
an
an
employee.
employee who is not a designated person, you have a information that he is possessing UPSI. So these names also need to be entered.
Absolutely, because designated persons is one set of people. Person who has access to UPSI ordinarily is covered under designated persons list. But the actual person who's working on something is one who's covered as an insider. The definition of insider has two parts: connected persons and any person who is in possession of unpublished price sensitive information. So that person may not be one who knows the results on a regular basis, but one transaction he is aware of. Therefore, his name goes into SDD and you tell him he cannot deal in the securities of the company. So, a connected person and an insider with respect to a transaction may be different for different things. So, actually, from a calendar based perspective, every listed company will have four instances of UPSI necessarily, the four quarterly financial results. Other than this, are event based ones. So, the first four are calendar based UPSIs, the other are event based UPSIs. If there's no event, no UPSI in the second bucket. But if you're having a UPSI with respect to an event, any person who has access to it, he may not be a designated person. His name gets entered. So when you're entering, you will need to have his PAN, you need to have his details. You also will have to create deemed connected person of that person's spouse, and all those details will also have to come in. The SDD will only have his name, but it is necessary to get the other details also.
Thank you, madam. NBFCs sharing the details like during the due diligence process, whether these also needs to be entered in the SDD, madam. Any NBFC companies which are in the due diligence process, they will reveal a lot of information. Whether all those things will be entered in SDD.
So, what is that due diligence about? So, regarding there are various types of due diligence, and if it is price sensitive, yes, it should be included in the HDD, and who starting from the origination of the information, source of information, and what is the so it should correctly capture what is the flow of information to originator to X to Y, whatever. So it depends on what type of due diligence you are talking about. In case it is a certain type of, say, general routine due diligence, I don't see any reason. But if it is kind of a sensitive information, UPSI kind of an event, then it should of course be included.
Maybe for investment purpose, it may be for funding purpose, it may be for third for regulatory
Yeah,
purpose.
definitely. Then it should be included in the STD.
Yes, sir. Similarly, whatever information we share with the banks for project funding and all, where the material information is given. So whether these also will be need to be entered, sir?
With respect to the first point on due diligence, I would just like to add. See, due diligence will fall under two heads. Due diligence based on information which is already in public domain. SDD entry is not required. Due diligence which is not in public domain, you need to see whether it is confidential or not. It may not be in public domain, but at the same time, it may be something which is not UPSI. But you will have to examine as to whether it is UPSI, not UPSI. Based on that, you would be deciding whether to make the entry or not make the entry. Okay. And of course, you will be guided by the basic definition. But whenever you do due diligence, typically you would say that you would have a non disclosure agreement also You typically will not give material which is not available in public domain unless it's a sensitive thing. So if it is one of just lending, then ability to pay is basically determined based on publicly available information. If it is a listed company, which is what it is, you will be giving the results as per the last quarter results, which is already there in public domain. So everything would be in public domain. If it is one of acquisition, it's a different issue. 100% you will have to make entry in the SDD then.
Okay. Another question is, how long will the non-compliance displayed on the page? The non-compliance is made good, madam. Is it till the non-compliance is made good, we have to keep displaying?
Sorry, you're referring to the
Yes,
annual secretarial compliance report? Answer is yes, yes. Go ahead, Manish.
yeah, I think he's referring to the SDD non-compliance, which is
Yes, it
displayed
is
on the
non-compliance reporting.
NSC website. I need to check that because it is the listing team of ours which handles that. But I think it should be till the. I think Sanjay sir would throw more light up on it, but yeah, need more clarity myself.
I think you're right. It should continue till it is remedied. No? Otherwise, there's no point in putting it actually.
Yes, once there is a process, actually, the exchange will verify whether the company is complied or not. Till the exchange is not satisfied, the name will be displayed. If the exchange is satisfied after carrying out an inspection, then the name will be removed.
So we need to get a letter from the confirmation from the stock exchange that it is there. Okay.
Confirmation from the company, basically from the practicing company secretary will confirm that the company is now compliant, and then exchange will carry out an inspection. Pursuant to that, if exchange is satisfied, they will remove the name from that get code list.
Sir, one more question. I think whether Savitri madam will give answer for this. Madam, regarding because it's a secretarial auditor perspective, you are only the company secretary. So the secretarial auditor, they will need to maintain separate SDD software, madam, and whether the company can rely on the company. Manish sir, you can also give you. The secretarial auditor who will audit and give the certificate in the compliances of SEBI regulation.
I may not be aware, so I think Savitri ma'am would be in a better position.
So there are two roles that the secretarial auditor is performing. One, as the secretarial auditor. As a secretarial auditor, if he is coming in after the end of the year and he is not getting anything which is unpublished price sensitive information, then he is only auditing. As an auditor, he does not have to have SDD of his own. However, if he is also if he is also coming in possession of unpublished price sensitive information, then as an intermediary, there's an obligation on him to maintain SDD, for which he will definitely have to have his own software. I mean, his own software as in not rely on the different companies who are maintaining, but get a licensed software in which he maintains the details of different companies, because who received it at his end, who has he passed it on to, and what is the flow of information. That continuity and trail will be maintained by him, whether it is the secretarial auditor, statutory auditor, or otherwise.
Thank you, madam. And how will be the financial results information, or whether it is initial or final tally data sort of thing related to financial results must be entered in SDD, and whether the flow of information also to be noted there.
Sorry, come again.
Financial results information, madam. Financial results,
right,
which will run through the software like Tally.
right.
Whether it will need to be entered in SDD, and whether flow of information also, because it may pass on through from finance department, account department to finance to other people in the.
See, what is the purpose of SDD? SGD is supposed to track as to who are the persons who are getting the unpublished price sensitive information. So once their name features in the SGD, you don't have to write the same thing as to who has passed it on to whom. If let's assume Mr. A has given it to Mr. B, Mr. B has given it to Mr. C. All three names A, B, C will feature in the SGD. Now let's assume C has done some processing and he has given it to A. C to A need not come in the SGD because they are anyways there. It's like getting a stamp on your on the back of your palm saying that you are now in SGD.
Okay.
So that is the way I would go from a principal perspective. If you track flow of information, every small thing you will be entering. I wouldn't say that is wrong, but that's not required. What you're trying to see is who are the persons who've been privy to unpublished price sensitive information. That's the basis which you're trying to track.
Madam, in view of this, in the digital era, anything may happen. So, is there any backup sort of thing which will be taken from this SDD? Because sometimes systems may not cooperate or some issues may be there. Is there back-to-back support things we will need to take care, or because we have to be having access till the time of issuing the certificates?
It is always better to have a backup for everything that you do. So I would say it is good to have a backup.
At what stage should we implement structural database? Company proposing to IPO, and till it is proposed to be listed, it is before the DRHP stage, sir, or as per earlier answer, it looks like before DRHP is submitted, we need to have systems in place.
So once the DRHP is submitted, you are basically letting the whole world know of your intention. From the time you start preparing for, and you've made steps, taken steps to involve people. As there was this beautiful cycle which was shown with respect to a tender. Similarly, over here at the ideation stage, maybe the UPSA doesn't come in, but at the action stage where you have started implementing this particular idea is the stage from where it comes in. However, in case of an unlisted company at that juncture, what is it that we are going to be tracking is important. Of course, it is quite possible that certain persons have bought shares at that stage. What would be the implication and how exactly the regulator would be tracking it may become important.
Sir, whatever software we get for the SDD, maybe multiple software vendors are available. Whether this needs to be linked to the stock exchanges as well, or how it will be integrated and interconnected to the stock exchange.
No, there is no linkage with exchange as such. This is a software which is internal to each company.
So the data flow and all you will check independently from
So the
your.
data flow is the reports are extracted by each company. Whenever we call for information, it is the information that is extracted from the system and which is provided to us.
Okay, sir. What is the time period of capturing any information on SDD? Sir, it's just like 2 days or any basic thing.
Yes, yes. 2 days.
If any agenda items, like in a board case of board meetings and all, agenda items are required to be circulated well in advance as per secretarial standards, no, madam. So what is the time or date when we need to enter these informative things in the SDD data, madam? In case of board meetings proposed and agendas and all, we circulate well in advance. What will be the probable date when we need to enter the details into SDD normally?
See, the information does not become UPSI when you circulate the agenda. When you circulate the agenda, the persons who are receiving the agenda, if the agenda has any unpublished price sensitive information, then those persons become privy to it at that juncture. Let's say, for example, you have circulated the agenda which says to consider and approve the financial results, but you have not circulated the financial results. Directors have not come to know anything which is a UPSI.
Even merger sort of proposal, madam?
Sorry?
Structuring merger sort of proposals.
If you have written something in the agenda, let's say you have written in the agenda to consider and approve merger of XYZ entity with the company, then you have given the information out. The
Okay.
persons who are recipients will all get entered in the SGD. If you have written to consider and approve any other business as may be permitted by the chair, and at the meeting it is brought up, you've not circulated anything. Until you have circulated, you've not passed on any information. Okay. You may have given a notice of the meeting saying meeting is being convened. People come to the meeting, and at that meeting you have told them, they've come to know only at the meeting.
Okay.
With respect to financial results, from the time the accounts department starts working, from the time the trading window closure starts, or whatever is the system, from that day onwards the SDD entry starts getting populated. But directors, but from the time they come to know, their names will get entered in the SDD. If a company has been circulating it, let's say 5 days in advance, directors' names will feature 5 days in advance of the meeting. If you have not given anything, just writing financial results, you don't have to make an entry because you've not shared UPSI.
Okay.
The test is UPSI going.
Oh. Sir, question for you. The stock exchange, what is the time frame within which the stock exchange initiate the inquiry where there is a doubt? And for completing the inquiry investigation, and if there is no indication of a time frame for completing above actions, what will be the practice normally you adopt?
So see, it is all case to case basis. So I will not be able to disclose much on this, but generally what we do is that in case we require any information related to HDD or related information, what we do is we write to companies and seek information from them. We expect them to provide it quickly, say within say 8 to 10 days maximum. So and many companies as we had highlighted as a challenge, many companies do not provide this to us because we are expecting this to be readily available with them, and we are expecting, and the regulator is also expecting that they are regularly making entries in the SGD system. So in that sense, I think much needs to improve on that timeline aspect. So which will also help us to kind of acquire information in a timely manner from the companies and not follow up with them repeatedly.
So one more question. The details of the EP normally required to be maintained. So what kind of details it is? Just like a name, PAN number, or regulatory backup, or any other specific data which we need to have, give inputs in this SDD. Sir, you are in mute, sir.
So yeah, we had shown this in our presentation. Generally, what is included is the PAN of the person who is so information flow from A to B, the PAN of A, then PAN of B, then I'll just let you know what is the information that is being passed on. Then what is the date of that specific this thing passing on that information. Then pan of all individuals timestamp. Then there are other details like mode of sharing UPSI, when date when the information ceases to be UPSI, if there is any kind of confidentiality agreement, date of agreement. So these are some of the fields which we have seen from our experience are included in this. But of course, companies may add add any detail which they want to. So these are some of the details, mainly the recipient PAN name and timestamp. These are some of the basic things which are included.
Okay. Sir, one more thing. Normally, madam, depending upon the size of the company, number of the employees involved and all, we will need to select the this software vendor of SDD, or how you will categorize, madam? What when we want to select, is there we can go to anybody who will all will be providing similar kind of data? You might have done some inquiries earlier when you want taken up this.
So, selection of a vendor here, you need to see whether the vendor is fully compliant. If the person is doing it for the first time, you have to do a proper UAT to see. I'm not saying that the vendor will not know because he's doing it for the first time, but the company secretary will have to be assured. Test the report, make few dummy entries, see as to how the audit log is generated, see whether edit is possible, how access would be given. Do a complete UAT so that you get to know what are the features, see how the features work. Getting to know from the seller is one part of it, trying to test it out by using it is another. There are some very good products available in the market. This needs to be done and then select it.
Next one is one more question is there. Can some guidance be given on when an information will transition from UPSI to be an information that is credible to be disclosed to the general public under Code of Fair Disclosures?
Sorry, this question is for the regulators, stock exchange.
Vijayan sir or Sanjay sir?
Vijayan, you can comment on that actually. The question is not very clear, but well, whatever understanding we have.
Can you repeat on the question, please? It's not clear.
Question is, when the information deemed to be will be in transition from UPSI, which will be credible to disclose to the general public generally under Code of Fair Disclosure. This may be the I think specific query got from a hypothetical case, I think. Sir, another one we can take is, sir, what is meant by expansion of business, which is not in the normal course of business, as mentioned or defined in UPSI? Can you elaborate on this? What would be considered as expansion of business? Hello.
Questions for us?
Regarding expansion of business, sir, when we can consider this as UPSI? What kind of situations? Because normally companies keep growing and keep doing some or other activity, like setting up of branch offices and all. Whether it will be considered as expansion or only setting up of a new factory setup or new project, then it is taken as a expansion of business.
Yeah, when it's considered to materially affect the price of the script.
It all depends upon whether it is impacting the price.
Material too.
Okay, sir. Madam, another question is, if a company secretary is unaware of any confidential information shared at high level management, what would be time to be considered as germination point of SGD, madam?
SGD has no correlation with the company secretary getting to know or not getting to know. If the company secretary is not aware of it, somebody else who's aware of it will be the person who's entering it.
So designated persons who is having access to enter, all these will be the responsible persons.
Yeah, the compliance does not get diluted because the company secretary is not aware.
Okay.
It's not that the company secretary alone has to make the entry.
Another one is in case where company is not doing any business operations, but it is still not closed, it's wound up. Even in that kind of situation, this SDD mechanism has to be implemented because many companies, there is no trading or thinly traded and there is no activities in the company.
Very much. So long as you are listed and you have a script code, you have to comply with it.
Okay.
It's quite possible that you may not have any entry to be made because there is no UPSI, but such a company will also have financial results. So you cannot say there will be no UPSI. Calendar-based events will happen.
Okay. And in some of the cases, practically, madam.
Question is, what if the script has been suspended?
Okay.
Okay. But answer to that is, even if the script is suspended, listing is continuing. That means trading is stopped, but listing is still there. So that is the reason I would say you need to comply with PIT regulations.
Okay. Okay, madam. Another one is a practical aspect of PA regulations, which is like a credit of shares through corporate action for allotment under depository system, and the listing and trading takes more than normally 2 working days from the time of acquisition or allotment. So in view of above, whether the company is required to disclose under 7.2 of PAT in Form C within 2 working days allotment, really like ESOPs, where more than 10 lakhs in value in the quarter is involved. What do you guidance, madam?
So ESOP will only be to a person, this compliance of 7.2 is only with respect to designated persons. And designated persons, it's already covered under system driven disclosure. So there is no 7.2 applicable in case of system driven disclosure. Only if the relatives, now relatives will not be given ESOPs. So with respect to relatives, the immediate relatives, it will be one where you have to comply with the requirements of 7.2, which also very soon from October 1st, all the companies will be covered under this system driven disclosure. Corporate action in the form of right shares and other shares being acquired, yes, once the corporate action is done by the company, an intimation and allotment advice is sent by the company, at that stage they must comply. But once again, in case of designated persons, it is system driven disclosure. So it's only the relatives where up to 1st of July or up to 1st of October, as the case may be, one needs to comply with it. After that, it will become automatic, which is really very good. It's a very welcome move.
Another question is whether non-executive directors, independent director to be treated as designated persons, do we need to include them, their immediate relatives also?
So, non-executive director is also a director, and 9.4 covers directors. So, you will be covering the directors. Their immediate relatives, once the immediate relatives get covered, you need to cover them also.
So similar thing even for KMP also, madam. KMP director, senior management.
Absolutely, yeah.
And in case of pledge and unpledge, is also considered as a trade, as we discussed. So how to deal with the situation where ESOP's funding is availed by the DP and the shares are and unpledged in a short duration?
Once again, DPs automatically it's covered under system driven disclosure.
Okay. So even for a short period of time, pledging, unpledging, that also to be
Correct.
considered.
Correct. Correct. Only thing is take pre-clearance, say that this is the purpose, you're going to be exercising your ESOPs, you're doing this, and it automatically comes in the stock exchange site.
Sir, Badi sir, the post amendments of these regulations in 2021, SEBI allowed cashless exercise of ESOPs options. Can an employee opt for 100% sell of all options? When ESOPs trust will sell all options on behalf of employee and transfer the balance amount of sale proceeds after deducting exercise amount and tax amount. And employees exercised for 1,000 options through cashless or ESOPs trust sales, 400 like 400 shares, etc. Exercise price and balance 600 out of that 1,000 options. Whether we need to make a disclosure under 7.2 of PIT for whole 1,000 shares or 600 or 100 shares. What do you your perspective on this?
No, I didn't don't have clarity on the entire question. Can you repeat that?
The question is where there is a cashless exercise of ESOPs normally through trust. What will happen? The trust will we can even employee can ask to sell the entire options and give us the balance amount after tax and the price amount, or they can also ask for the entire password. In this case, in case of like example, 1,000 options are there, where it is asked for 600 options to be sold and 400 to be transferred. Whether we need to give information about whole 1,000 options which are opted for cashless exercise, or we have to give only how much are exercised under 7.2 of regulation.
From my limited knowledge, I think it is based on value of the trades. If it exceeds a specific threshold, that is what I am aware of.
Okay, sir. Madam, one another question is pre-clearance is required to be taken from the resigned designated person. Madam, I think you have been explaining in your session.
There is no pre-clearance from a resigned designated person, but the designated person who is resigned needs to be mindful of the fact that for 6 months, his trades will be covered as connected person. So he needs to be careful. And therefore, my advice is for 6 months, please don't trade. After 6 months, it's a different issue. Of course, it is also possible that something which he was working on is still not in public domain, but that's for him then to be covering. So it's presumed that in 6 months, unpublished price sensitive information becomes price sensitive information and publicly known. That's a presumption, rebuttable.
In these situations, madam, how can we control normally PMS trade violation in case of companies and intermediary sort of thing?
So, in case of PMS, when you execute an agreement with the portfolio manager, there's something called grey list. Typically, what happens is people end up signing at the end of the page wherever there is a cross mark done with a pencil. Don't do that. Please ensure that you very clearly state that these are the companies where I do not want the PMS to trade on my behalf. And therefore, get a confirmation from the portfolio manager saying that they have taken note of your grey list. Get this confirmation on a yearly basis so that you're fully protected. While once you take it, you're protected, but it is always better to be more careful than to be sorry later. So that is the reason, keep on saying, even if there's a transfer at their end, you're being vigilant. Of course, somebody may ask me a question, what if the person gets transferred middle of the year? So, that is something which you live with. So, what you do is at least once in 3 months, keep talking to your relationship manager so that you know that the same person is handling it.
Okay. It is similar, madam. Question is like relative and immediate relative are both are at par in relation to SDD, or any specific relaxations are there?
So, under PIT, the term used is immediate relative. In ICDR, you have the term of relative, but under PIT, it is only immediate relative. You have to be careful under PIT with respect to Regulation 6 and definition of immediate relative, which is also used in the context of connected person.
Actually, there are so many questions, madam. Still,
No, I think we will also have to
that's
close
why,
because it's.
I just want to take your
We can have one more webinar.
and Sanjay sir also, because the subject is so dynamic and so practical. Every day is a new day, and every day is a new subject for everybody. So, friends, Surbhi, can we close now? We need to close. Yeah. At the outside, I would like to, thanks for all your questions. Actually, there are 75 plus questions. I could able to take majority of them. The questions I have not taken as the answers from the in the presentation, from the answers of other questions already covered. So I could not taken those questions. So, and wherever possible, I could able to cover majority of the questions. Thank you very much for your continuous participation. And before the closure, it is my prime duty that I should acknowledge and endorse, express our regards to the great eminent panelists and speakers for the day. First of all, I would like to thank Sir Sanjay Sir, CGM SEBI, and Vijayan Sir. Sir, thank you so much, sir, for your continuous support and guidance for the ICSI. Whenever we called upon, you are giving your fullest support for extending knowledge, giving your clarifications to all our members. Thank you so much, sir. Of you. Then it is my also duty to thank Manish sir and Vishnu sir, who are patiently with us for last 2 hours, taking all the questions, giving all the inputs and insights on the subject. Thank you very much, sir, for your wonderful presence. You have covered lot many things which are given almost all clarifications, but still the doubts will keep coming. And Savitri madam.
It's our pleasure, sir. Thank you.
Yeah. Savitri madam, wonderful madam. Thank you so much for answering all our questions, especially practical way. Your experience shows how you could able to handle such a size of organization and so many practical issues. You could able to throw light on us. Definitely, your presence and your guidance is always required for us, sir. Thank you very much on behalf of ICSI, madam.
Thank you very much. It's been a pleasure. Thank you.
Thank you so much. Thanks a lot.
And I thank all everybody, even Surbhi and madam, for organizing this program. Sir, we will be, requesting you, the troubling madam and Manish sir, all of you, for our other programs for continuous education process. Thank you once again for giving all the support. And finally, I take leave from all of you and will be get connected in some or other program. Thank you very much, sir.
Thank you. Thank you so much.
Thank you.